The chair now lays out Senate Bill 14 and recognizes our colleague, the vice chair, to explain the bill on behalf of its author.
Thank you, Mr. Chairman. Thank you, members, for the opportunity to lay out Senate Bill 14 on behalf of the author, Senator King. Currently, Texas law enforcement agencies do not follow a standardized procedure for determining the confidentiality and release of peace officer information found outside their personnel files. Instead, the confidentiality of peace officers' personal information, such as background hiring information and unsubstantiated complaints, is determined by the policies of the employing local political subdivision. Consequently, peace officers' personal files may not remain confidential unless a city has adopted policies clarifying the peace officers' files, which are not expressly subject to public disclosure, must remain confidential. While many Texas cities have adopted these policies, the majority of Texas cities have not. State-level Department of Public Safety troopers and over 20,000 peace officers employed across the state already have these protections. Senate Bill 14 extends these protections to all Texas peace officers by, one, establishing a departmental file to house documents related to peace officers that are not otherwise required to be included in their personnel file, and two, mandating that the contents of this file remain confidential. Under Senate Bill 14, the contents of a peace officer's department file will still be available for disclosure for, number one, misconduct investigations and standard hiring procedures, and two, ongoing investigations by the Texas Commission on Law Enforcement, TCOLE. And this was actually a recommendation of the TCOLE Sunset review. Importantly, the bill clarifies that its provisions do not conflict with disclosure required by the Michael Morton Act, third-party law enforcement under the Sandra Bland Act, and a meet and confer agreement entered into before September 1st, 2025. Thank you, Mr. Chairman. Thank you, members, and there are some witnesses here who can further explain the bill if there is a need for that.
Thank you, Senator Paxton. Members, any questions for the vice chair on behalf of the author? Very well, we'll open testimony, begin with invited testimony on Senate Bill 14. Chair calls Jennifer Szymanski, testifying in favor or for the bill, Senate Bill 14. And after Ms. Szymanski, we'll open up public testimony. Welcome. Get situated there, introduce yourself, give us your testimony.
Thank you, Chair, Vice Chair, and Senators, members.
And get a little closer as you do it, please, if you can.
Okay. I'm Jennifer Szymanski. I'm the Deputy Executive Director for CLEAT, the Combined Law Enforcement Associations of Texas, here on behalf of our 28,000 members. Thank you for the layout, Senator Paxton. This all began back after the 88th legislative session, where the TCOLE Sunset Bill actually mandated in state law that TCOLE form committees of stakeholders, and those committees of stakeholders were to develop model policies in several different areas. One of the areas that they were mandated to focus on was personnel files, thus the model policy, which is now the bill in front of you. There were several other areas that they were required to develop model policies in. This is just one of those. One of the reasons in the legislative intent, as being part of the conversations with Senator Paxton's staff, Representative Goldman's staff, the legislative intent behind these model policies was to establish a standardization of the way we do things in law enforcement in certain areas where we lack standardization. And this was one of those areas. CLEAT, labor, chiefs, sheriffs, as well as civilians, HR directors, city managers were part of the committee of stakeholders. These stakeholders met between the months of September and all the way through January to develop the model policy that was then voted on by all of the TCOLE commissioners unanimously on all policies, including the personnel files policy, again, which is before you today. As the senator mentioned, this needs to be codified, and the committee, the way that we developed this model policy was we started with Chapter 143 Civil Service. So Chapter 143 Civil Service is the only form of standardization out there currently. That's why we started with that. As you can see in the memo that we've circulated, 26,000 plus peace officers currently enjoy the language in the bill. This would bring the remainder of those officers into the same confidentiality standards. And that's exactly, again, what this bill does. As Senator Paxton mentioned, it is in state law currently, and the default that the Attorney General's office would use if they were asked for an opinion, which they are many times on these types of files and requests, have to default to not policies, but state law, which would be Chapter 552. So either you fall under 143, state law, or 552, the other state law governing FOIA requests. Again, the adoption of Chapter 143 Civil Service is extremely cumbersome. That is the only reason why several of our agencies have not adopted it. And you can see that it's evident in the way that they are, in the way that they do business today, because they're mimicking civil service. If you look at cities who do not have civil service, they are mimicking those standards. Much easier to do that than to hold an election and have to put something on a ballot. That's how we came up with the model policy. It needs to, unlike the other model policies, this one needs to be codified because, again, 552 is the default. So this must go into state law. The model policy went into effect June 1st of this year. We were hoping to have this through. It passed the Senate, but died in the House. We were hoping to have this through so that there is no conflicting information between the model policy and the current state law. There were 3 amendments that the Senate took on, and the bill today you see before you is the bill as it passed the Senate. And again, as the Senator mentioned, those amendments were to clarify what's currently in state law already, but again, further clarifies that this bill does not prevent the disclosure of any records on an officer when it comes to the Michael Morton Act, Sandra Bland Act, and again, any meet and confer contract that is executed does supersede state law, and that's in current 143 policy today. I'm happy to answer any questions.
And thank you for your testimony. Members, any questions for our invited witness? Thank you.
Thank you.
And Jennifer, just in case some questions come up, you okay to hang around for a little while just in case? Thank you very much. We'll open public testimony. And the chair calls Mike Swanson. Juliet Thurber. Rai Vasquez. Charlotte LeMay. Jonathan Blanchard, Lieutenant Jonathan Blanchard. So looking for Mike Swanson, Juliet Thurber, Rai Vasquez, Charlotte LeMay, Lieutenant Jonathan Blanchard, C.J. Grisham. I saw C.J. earlier. Brent McCain. All right. Have a seat, make yourself comfortable there, and get close to that microphone. We'll normally start on your end, so get close to the microphone, introduce yourself, and go ahead. Welcome.
All right, my name is Brent McCain. I'm representing myself, and I am in opposition to SB 14. So on September 15th of 2020, during the height of COVID, I entered a convenience store in Central Texas. While inside, I was confronted by a city police officer who demanded to know why I was not wearing a mask. I informed him that I did not have one, at which point he stated that I must leave or be cited. I tried to explain to him Governor Abbott's executive order GA-29, and he ignored that. And basically, I exited the building only to turn around and find out he was pointing a taser straight at my head. I was detained while he called for backup. 6 officers arrived for a mask violation that, according to Governor Abbott, I should not have been detained nor arrested for. I was arrested, handcuffed, put in the back of a police car. So fast forward a little bit, I submitted a number of open records requests. A lot of that was delayed because of like body cam video. I did eventually get it all. However, it was difficult to get a lot of the information. Luckily, I had my own body camera on, and I did that because of all the madness surrounding the mask mandates. And without that, it would have been even more difficult. So basically, without that, I wouldn't have been able to. Anyway, I oppose SB 14.
And thank you for your testimony. Welcome. Introduce yourself. Welcome back. Introduce yourself. Give us your testimony.
Hello again, Senators. My name is Mike Swanson. I stand in opposition of Senate Bill 14 because of stories like his. If we're to allow records of our law enforcement to remain closed off and not able to be subpoenaed, that leaves instances where he cannot seek justice. And in a country like ours, it's important that we're always able to find justice when injustice has been caused. As a citizen's perspective, I like to think back towards what the Black Lives Matter protests that happened many years ago and think about the reasons why those existed. The enforcements that have been caused well past necessary authority. Now, I'm not strictly opposed to law enforcement. I believe that law enforcement does have a vital service to our community. However, in certain situations, there are bad things that happen to where authority is overstepped. Things that are used with excessive force versus being able to manage the situation. On a case-by-case basis, it's understandable to why a police officer or law enforcement personnel would overstep their authority in some cases if necessary to protect their own human life or to protect those around them. But we do not need to block off the ability to have a citizen's check on our government when the government has done us wrong. As the Republican Party, I thought that y'all would care more about keeping the government in check, not protecting those that overstep their authority within it.
And thank you for your testimony. Welcome. Introduce yourself. Go ahead.
All right. Good afternoon, Chair and committee members. My name's Lieutenant Jonathan Blanchard. I'm here representing the Dallas Police Department in support of Senate Bill 14 as an opportunity to make some specific reports confidential. Automatically generated reports related to officer performance and attendance provide a good starting point when addressing an officer's productivity. We would like to utilize these reports as part of an early warning system, but we are not a Chapter 143 civil service agency. As a result, reports related to an early warning system, including performance improvement plans, would be subject to release even before their accuracy is verified. Additionally, reports related to an officer's use of sick leave, vacation time, and when they choose to take their holiday are subject to release and are not currently confidential. If an officer's performance or attendance rises to the level of misconduct through violations of policy or law, then it becomes a matter of public concern and our department has no issues with releasing that information. Until such a scenario, we'd like to keep attendance and performance-related reports confidential. Thank you for the opportunity to speak in support of this bill on behalf of the Dallas Police Department, as this bill provides us with an avenue to be a responsible employer by developing our staff and implementing a robust early warning system.
Thank you, Lieutenant. Thanks for your testimony. Welcome back. Introduce yourself. Give us your testimony.
Thanks, y'all. I hope we spend a little bit more time voting on this rather than the past bill. But my name is Rai Vaz. I'm opposed to this bill. I think making it harder for people to hold cops accountable will encourage cops to break the law. I'm sorry. There's no secret we've handed law enforcement a blank check anytime there's wrongdoing or they do something horrible. Wrongful deaths in the past decade average about 1,000 deaths per year. In 2023, an officer was captured on tape laughing about a woman he ran over going 74 miles per hour down an alleyway. How did we know about him laughing about this? Released body cam footage. And now you want to give information to a private company or license holder who, under your law, could ignore FOIA requests? I don't know, the bill was about a page long. There were no carve-outs for that or any kinds of guidelines. Your bill also includes that documents related to alleged misconduct by the license holder for which the agency determines there is insufficient evidence to sustain the charge of misconduct be included. Now, I don't know about you, and I don't have any real background in law enforcement, but from what I've seen about this is that holding those things, even if there's any alleged wrongdoing, will disadvantage people who are seeking justice from those things. I mean, how is a lawyer going to defend someone who faced police brutality? How is this going to do anything but disadvantage the public at large? I mean, recently a man was pulled out of his car and his car seat belt was ripped off, and we only really knew it because he was filming. We didn't see it until later when there was public outcry that the body cams were released. Much like the panelists in front of me today, law enforcement officers are public servants. They're not above the laws they protect. I don't know what Orwellian fascist wet dream you're seeking to create with this bill, but I know when it comes to the rights being taken away, it only takes small bills like this to pile up into a hellscape where secret police can arrest people all the doodah day or just get away with murder. It's not good. Don't pass the bill.
Thanks for your testimony. And hold tight. I'm going to call the next panel, and we'll be ready for you. So hang on just a second.
I won't take it personal.
I didn't think you would. Thanks. So we'll, on the next panel, we're going to be looking for Juliet Thurber, Charlotte LeMay, Melody Tremalo, Emily Gogol, also for Chief Deputy Jason Warren, Kathy Mitchell, Ananda Tomas. I've called a few extra names because some folks have left. But if I called your name, please be on the Senate floor so we can get you on the next panel or the one after that. And welcome back. You know how to do this, and you don't need to get close to the mic, but I don't have to remind you of that. You're welcome to. Introduce yourself for the record. Give us your testimony.
Thanks. I got that first sergeant voice. My name is CJ Grisham. I'm here in opposition to SB 14 on my own behalf because as a civil rights attorney, SB 14 is perhaps one of the most dangerous bills I've seen since I began coming to the Capitol and advocating for and against legislation. SB 14 should be named the Protect Bad Cops and Let the People Eat Cake Act. I feel this body needs to be reminded that Article 1, Section 2 of our Constitution says that, quote, all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit, not the benefit of government agents who violate that trust that we, the people, placed in them. I'm a retired special agent, federal agent. I've got my retired credentials here. I've got my TCOL certification, so I'm not anti-cop. As my website suggests, ISueBadCops.com, that's what I do. I sue bad cops. This is going to protect bad cops. It's going to make it harder. As a civil rights attorney, I can't tell you how many times I've got somebody that comes to me and they want to file a lawsuit, and I can't access through open records, okay, well, has this officer done this before? Because as we all know, the police investigate themselves and find no wrongdoing. This happens more often than not. And they want to protect this. Good cops are not afraid of having their records exposed on discipline, attendance. You know what, if my cops that I pay for taxpayers aren't showing up to work, I deserve to know they're not showing up for work. If they're taking extra vacation, I deserve to know that they're taking extra vacation. I don't need to know their addresses and their social media and their private information. I'm talking about when they're on the clock. And it is difficult as a civil rights attorney, as it is under the current law, to be able to get information. And it forces people like Mr. McCain here to pay thousands of dollars to an attorney to find out what we should be able to get anyway. We're moving in the wrong direction. 552 covers up way too much. This is going to cover up even more. And we need to be more open and transparent with how our law enforcement act and not hide stuff. Good cops aren't afraid of sunshine. And I ask you to vote against this bill.
Thank you for your testimony. Senator Perry, you have the panel.
Thank you, Mr. Chair, and I'm not sure this is why I wanted the resource witness to hang around. It may be more appropriate. She had laid out kind of how we got here, but not actually what the bill did. And my recollection and the origin of this conversation has gone on for a long time if it's the same concept. So I'm going to ask the gentleman in uniform there, the officer, and if you're not comfortable or you can't explain it, it's not going to hurt my feelings because you would be one of several, I'm afraid, that we're going to find out that can explain it. And maybe I'm wrong on the background, but this started kind of as an employment issue several sessions ago, and it'd been ongoing. I remember I've been here 15 years. It was old conversations, and I'm going to reference things, and if they're not applicable, to say this doesn't have anything to do with it. I remember there was something referred to as a G file. Is that relevant to this conversation?
Yes.
Okay. And the origin or the conversation that ensued back when I was looking at this, because we had some bad police people. They're human, right? We get good ones and we get great ones, and then we get one or two bad ones. And what we found was no different than our school systems, et cetera. We're, quote, passing the trash. And so we opened up the G file as a required conversation between one department and the next when they were looking at hiring someone. So that if you're a bad guy here, that G file was absolutely required for the person talking about hiring you so that we would stop passing the trash. So with that as a background, is this the G file that we're talking about prohibiting from public disclosures? And if it is, great. If it's not, and then I'll probably have a conversation for CJ to follow up on. But is it that file?
From my understanding, this is the file that contains allegations of misconduct or any other information that is not substantiated, the exonerated, false reports, such information such as that is prohibited from public release.
So what I hear you saying is we don't have a problem going after bad cops with full disclosure, but what we don't want to do is go full disclosure of something that has not been vetted and proved.
Yes.
All right. CJ.
So here's the problem with that. It sounds good, and that would be great if that's how it worked. But what happens is a police officer gets accused of misconduct. Rather than go through the process of an investigation, that police officer resigns. Guess what the police department does? And I'm talking these are cases I've had. The department drops any substantiated or any investigation because the person no longer works there. So once that officer quits because he's been accused of doing something, the department no longer investigates it, and it's unsubstantiated. But the people deserve to know if I'm the fifth, the sixth, the first person who was accused this officer of something. I know it's just an accusation, and as an attorney, I will look at that as only an accusation. But when you start seeing patterns, that's what we're looking for. That's what people want to know about is, are there patterns? And if this guy's getting accused of something and then he quits so he doesn't get investigated, so he doesn't get into the G file, and then he goes to another police department, and that police department doesn't see anything because there's no, that's what we're talking about.
So back to the officer, there's an F form, there was some form. What was it, F something?
Something like that. I don't remember.
So on that form, there was very general, let's just say very nondescript reasons for termination or retirements or whatever that is. So Has that form been modified to be more detailed?
So yes, at the end of an officer's exit of employment, we're required to finish all pending investigations to complete this. And that's part of us adopting that TCOL model policy on misconduct. So once we complete all those, all that information is sent to TCOL.
With or without, so if I did something and I quit, does the form reflect a full investigation even after I quit?
Yes.
So the concern that you're a bad guy, you quit so that it won't get out and you'll go to the next place and there'll be no record of it is not true
Right.
under today's reforms.
Under today's reforms that were just active a month ago.
Okay, so I'll go back to CJ a minute. Couple of questions.
Yes.
There's this really fine line, and this came up through a trial lawyer's bill during session, and after I understood the context, it made sense to me. And it was the trucker's bill. And effectively, the first stage was whereby I'd just call smart lawyering. They would bring in previous information into the first stage that would prejudice or bias the jury. And once they made their case at that level, then they would go into award damages. Well, the whole law was about taking the prejudice of a historical context off the table and look at that individual on that instant and that issue. And I use the example, right, wrong, or indifferent. If I'm a murderer 20 years ago and I served my time, did my crime, and I walked out on the streets today under a justice system, and then I got called in for something else, it's the something else that I should be tried on first, and then if I'm found guilty of that, then I should be punished accordingly with all the back history. So what concerns me in what you're saying is, one, if it's never been vindicated, but there is a documentation of the final investigation, be it internal, but I have to trust internal affairs and people at that point that are delegated that responsibility, that if that was a public disclosure that you bias or taint or possibly prejudiced before that person was actually dealt with on the issue of the present. So is ultimately all that stuff, if you were to go to a court, is all that stuff going to be discoverable and pulled out anyway once you've done your job as an attorney?
So yeah, that's where the difference is, where right now, if I want to get that information as an attorney for my client, I can do that if I file a lawsuit and then in the discovery process that my client's going to be paying for. What we're talking about, and I don't know if the new legislation that hasn't gone into effect yet is going to fix some of these problems, like as was just discussed, but I can tell you right now that here's the thing. I've been arrested 5 times. That's why I became an attorney late in life.
I know your
I'm tired of being arrested falsely. But you know what? If you go and you look it up, you're going to see 5 arrests from CJ, even though CJ never got convicted. Why? And that's good for me, because that shows that I'm not a lawbreaker, that my charges were dismissed. I would think it would be a good thing, whether charges or claims against an officer, if they were dismissed as unfounded, I'd want to know that as an attorney, because if a client came to me and I did my pre-litigation work through an open records request and found out, well, this guy's been accused, but he hasn't done anything wrong. I just don't see where we can do it. That's a good thing. It helps the officer to show that, hey, I'm clear, I'm good, but we want to hide that. And it's not just the bad, but it's also the good. And the people, the citizens who pay that salary and for him to do those services, again, we deserve to know, because what if there's been 12 different claims from 12 different people in 12 different areas that have all said the same thing about this officer, but yet for some reason that corrupt police chief keeps finding no wrongdoing. Sometimes where there's smoke, there's fire. Sure. But we won't know that with this bill.
So, Mr. Chair, when the members are through with this group, I do want the resource to come back and clear up current law that we passed that you said went in effect a month ago.
Yeah, it's just
Okay.
June 1st.
Thank you.
Thank you, Senator Perry. Senator Schwartner, you have the panel.
Thank you. On the lines of Senator Perry's questioning, there is concern that I have regarding pass the trash, whether it's regarding our educators or our police officers. In Williamson County, we had the Michael Morden case in which exculpatory evidence was hidden by the sheriff and DA a long time ago, and he served a long time in jail before he was released. We also had an unfortunate incident with a prior sheriff as well, Sheriff Chody. I think you actually referenced that. But I have some concern that this bill, which, if I'm reading it correctly, allows for the creation of a confidential department file to be produced and maintained if there was insufficient evidence of a misconduct, of an alleged misconduct. And on the surface, that seems okay, but as I think Senator Perry was saying, a chief that's befriended somebody that is a subordinate could continue to hide wrongful action. And then, if I remember correctly, when TCLOS went through sunset, and hopefully someone on this panel can help out with this, the chief of that department, whether it's a sheriff's department or a municipal police officer's department, has to sign some sort of form. Is it a pink form, blue form, something before their, L5, yeah, something like that. And so I want some clarification as to how this confidential file fits in with their L5.
I think it's an L5.
L5.
Resource witness.
The resource witness can help us with that? Yeah. All right, well, am I, CJ, I guess, you're an attorney, prior police officer?
Federal agent.
Federal agent.
I did
okay.
national security.
Am I thinking incorrectly that this could be a way in which bad cops can be passed on and are hidden from being properly overseen and any misconduct found out that they are perpetrating on a repetitive basis against citizens?
And like I said, you know, and by the way, I represent good cops too, by the way. I don't just sue bad cops, but I represent good cops. But I'm more concerned really what this does in a lot of the smaller towns where all the cops know each other and they're all buddy-buddy, and guess who the IA is? It's their buddies. But yes, I literally had, and I don't want to call out anybody, but I literally had a department tell me that, well, we dropped the investigation because he resigned. So there was no investigation done. I couldn't find out whether it was substantiated or not substantiated. I have to go off my client's word, which that's why I always tell my clients, record everything, because sometimes
this gentleman here, this officer, said that all those investigations get completed. Is that wrong?
As of a month ago. With the TCO model policy requires us to complete all investigations upon employee's exit.
Well, and what I would say to that, I understand where he's coming from. I am in no way demeaning his integrity on this, but I doubt he follows every single department, you know, whether it's an ISD police department, a city officer, the counties, the constables. And you know, I mean, we have laws on the books already, but guess what? They get broken. I gave you 2 pages of police officers just in the last couple of years who have been arrested for very serious crimes. So just the fact that we've got that's not what's happening in practice. And by covering up even more, we're just making it easier for them to cover it up. And it's already being covered up.
If I may jump in just real quick on this, because I don't have a lot of experience with Texas law enforcement, but in other larger cities like New York, I have family who was affected in certain cases like this. A lot of the times, whether it's law enforcement unions or different precincts or chiefs who are buddy and buddy, there'll be these officers who do have these allegations and they're ongoing investigations, but then they are transferred, so then the ongoing information doesn't get passed along until that is wrapped up, and then these other precincts will draw out that investigation so that the people don't get the info. It's an ongoing investigation. We're still looking in, well, it's been 4 months and this happened 8 months ago, and we're trying to start our trial on this issue. So when it comes to those kinds of things.
Thank you. It's a difficult issue because I think police officers are probably repetitively and wrongly subjected to misconduct allegations, especially in this day and age. And how do we handle that as a state regarding the allowance of a separate personnel file for unquote unsubstantiated, insufficient evidence type of allegations versus substantiated and true allegations are ones that should have been at least evaluated fully. So it's interesting. We need to ask more questions, I agree.
Thank you, Senator Swardner. Senator Perry, you're recognized.
So the resource witness, I hope, is going to clear this up. History with the agency, maybe not. CJ, one question, quick and easy. You have a client. You, under the old law, subpoena the records, freedom of information, and you get a list of 20 different times this person's been written up. All either ultimately dealt with and no problems, or 20 of a correct record you can't tell because, quote, quit one 15th and then did it again. But here's the question. I don't have the answer. Is there anything to keep C.J. Grisham from making that information public before you file a lawsuit?
Currently, yes. I'm sorry, say your question.
So I don't know. I'm not an attorney. As I've said 100 times, I chose not to be one. Didn't want to go.
Good call.
It was.
Yeah.
I'm still married 43 years to the same person after it because I think I didn't go down that road. It's a frustrating profession. But if you were to get one of these files because you have someone that has come to you and said, I've been wronged, is there anything that keeps you legally, not morally or integrity, because I think you're a moral and integrity guy, but you can't count on that. But legally, is there anything to keep you from making that information public before there is a formal lawsuit filed?
So not under open records, but under discovery rules potentially, and it depends on whether it's a criminal or civil case.
And that lies, and I was going to make that distinction, but you made it for me, civil and criminal, discovery and law processes. But since you don't have a formal charge, you're not formally lawsuit, you could say anything you want and disclose anything you want and then go to discovery after the fact, correct?
Correct.
So you could make a public case public and work the press and the public long before there's a formal lawsuit, correct?
That's correct, but I became an attorney to be an ethical attorney because I can't stand most attorneys.
I wish if most attorneys had your history and background, we wouldn't be having this conversation.
Right.
And we wouldn't be in quite the quandary that we as legislatures, with our good men and women in uniform, act. So I do look forward to the resource witness coming back up. Thank you, sir.
Yes, sir. Thank you, Senator.
Senator Birdwell, you're recognized. You have the panel.
Thank you, Mr. Chairman. CJ, the purpose of the bill is to, you'll understand these terms, I don't know if the other gentleman will, but the difference between the 201 file and the local file.
Right. I know what that is.
So,
even though it's Alpha 2-1 now.
yeah, I've been retired longer than I served, so they changed the names to confuse the retirees.
Right.
But anyway, so the 201 file is a permanent record, local file is kept only locally. So I think that's probably what we're dealing with here in analogy-wise, and that now, the difference is that the local file in a military unit is still an official record, but not permanent record, only for while the individual is in that organization.
And it doesn't follow
So it's not exactly congruent, the question I'm asking here. But I think, according to Lieutenant Blanchard, and then what I've read from the layout on the bill author is that it's designed for the things that are unsubstantiated. And when I read this list you've given me, are you telling me that this is all unsubstantiated that was hidden, or these are things that occurred, but there may be other things in these folks' files that was not accessible, but also not substantiated? Because I'm the one that had the trucking bill that because what we were, again, not to belabor, but what we had is in the phase one of a trial, it wasn't, what are the facts of this case? It's, hey, you had this violation 20 years ago. That's now evidence that, you must have had this violation now. So it corrupts the phase one of the trial as opposed to in phase one, if you're found substantiated or guilty, now that history can be brought into the penalty phase, but it shouldn't be in the trial phase.
And
So
to,
what I'm,
yeah.
so what I'm, I guess what I'm asking here is are all of these, I mean, everything from child pornography to DUIs, were these all things that were unsubstantiated in these officers' cases?
So in all of these cases that I brought before you, not all of these have been fully litigated. What I brought you, obviously, were extreme examples. But what I have seen, and the reason I bring these up, because I don't want to go into my personal caseload and potentially expose clients.
Sure, I'm not asking you to.
So I tried to be I tried to be both vague and a little extremist in the examples that I used. But in these examples, there are underlying allegations that occurred before this person was ever charged that were found unsubstantiated. And then come to find out that there actually was a conspiracy, or this person, it's not his first DWI, it's just the first time that he got caught, even though other people had reported him, hey, this guy's driving crazy, only to find out he was a police officer, and it was never substantiated. That's what I'm talking about, is those kinds of complaints that because each of these has an underlying victim to them, a citizen that is except for the DWI, there's a potential victim, but each of these has a victim. You know, I even included kind of a crazy one here: loafing, sleeping, inattention, and leaving his workstation. These kinds of things likely, and this one I don't know specifically, likely there were allegations before, oh no, he was fine, you know, kind of thing. So, but to a lot of these cases, and I tried to bury the story in the mass so that I wasn't pinpointing any clients. In a lot of these cases, there were underlying unsubstantiated reports that eventually the client was vindicated because the officer got caught later and kept doing it.
Because okay, well, let me finish what I'm, because the underlying pretense, and to Mr. McCain's concern, and I'll ask you a question here in a moment, but is that, innocent till proven guilty. Now, administrative procedures aren't necessarily criminal or civil procedures, so you don't get as high a rigor of formality in those circumstances. But we're trying to afford the police officer the same assumption of innocence that we expect law enforcement and our criminal justice system to assume of the citizen. Let me ask this, Mr. McCain, if I may. Did you file I'm not sure, I assume the word is complaint, but was there a formal complaint against the officer that?
Yes, sir, there was.
That is now in the record that is searchable, that is not set aside? But, again, Solomon tells us he who speaks first seems wise, till the second comes and examines him. So I only have your side of the story here, not the officers. But is your experience that you detailed in here in your testimony, your written testimony, is that case in an unsubstantiated file in the Waco PD, or is it in a substantiated
It has
file?
been substantiated,
Okay.
and
That
it has
would,
been litigated.
that would tell me that because, look, given the COVID stuff, I mean, don't like you having to go through this, but that would tell me that the system worked for you, that you had an experience that was not just unpleasant, but outside the bounds of what the officer should have done. As a citizen, you filed that complaint, I assume, with the police department.
Correct. It was, I filed it with the interim police chief.
Okay.
Actually, the assistant police chief, but it was difficult in order to file the initial complaint. And the information that I was able to obtain showed that the responding officers, the commanders and sergeants, tried their best to put the officer that basically assaulted me favorably.
Let me ask this. The way you said that is, in making the complaint, did you try to access previous events to substantiate your complaint? Or did your complaint stand on its own with the facts specifically of your experience from walking into that convenience store to being arrested and then filing a complaint? Because I think what I think the bill's trying to do is kind of like my trucking bill. The complaint ought to be based upon the experience with that officer. Not taking, if you were, convicted of murder 20 years ago, get out, and then there's a murder and you're charged with it, does the fact that you were convicted 20 years ago mean that you're guilty now? And the answer is no. So it would be appropriate that if and you've told me that your case was substantiated, then if you wish to civilly litigate it in some way for damages, then at that point, that other information may be relevant to a penalty phase as opposed to the guilt or innocence of the officer. Is that fundamentally what I think you're trying to express to me? That
Yes, and I filed the complaint, then I researched it throughout this time period, and I was able to get the officer's civil service personnel file. Not the one that the police department carried. And in that civil service file is where I found other issues or issue with this officer previously.
Okay. And is that civil service file held by CLEAT, TCOL, or was it a completely different public service organization besides the police department of Waco?
It's local.
Yeah, I guess it's been 5 years since then, but
Okay. Okay. Let me ask, Lieutenant, if I may, are your most effective officers, and I have not defined what the definition of effective is, but are your most effective officers the ones with the greatest numbers of complaints because of their effectiveness? Or is the numbers of complaints against an officer not statistically relevant to how successful they are in whether it's patrol, homicide, whatever their particular division is?
There is a direct proportion to the number of citizen contacts an officer has versus how many complaints they get. Now, that is not indicative of misconduct. That's just indicative of their activity. Right? It is possible to be an officer and go through your entire career and not get a complaint. That's a great officer, right?
Okay.
It is also very easy to have a few citizen complaints and every single one generates a complaint, right? I don't think, to your question, I think that yes, you will probably get complaints if you're a active officer and you're enforcing the law.
Okay. In a department as large as yours, I would assume, internal affairs does every department have somebody that's checking the validity and the veracity of, or is there an independent, and I say independent of the department's authority, that is checking the veracity or sustainability, not sustainability, that's not the right word, but the verification of a complaint?
So I can speak to what we do. We take a complaint when we preliminarily review it. If we can review body-worn camera and verify that it just didn't happen, we clear the complaint. If we don't, and we still have the complaint that we weren't able to verify that it was false, we will start an investigation, and then we will determine whether there's enough evidence to sustain.
Okay. Who checks internal affairs?
We have a civilian oversight board that we work closely with.
And how are they made up? Are they
they
appointed
have-
by the mayor? Are they appointed by, how do they?
Each council member appoints a board member, and we also have an office of community police oversight that works closely with our internal affairs division and reviews our investigations as we do them.
Okay, all right, thank you.
Senator, can I make one quick, and just a legal aspect of it? One of the reasons why it's important, because there's something called Monell liability. I don't know if you know what that is, but If I, as a civil attorney, want to sue the county or the city or whatever that entity is, I have to overcome what's called Monell liability. I have to show that there's a policy, practice, or procedure. And that policy, practice, or procedure would show an act or an omission of an act. And so I would need to know, like, okay, that's why it's important to know, is there a policy, practice, and procedure to allow all these things and find them unsubstantiated? Because then I know when I've got my litigant that comes to me, am I only suing that officer, or am I also suing the county or the city or the school district or whatever it is? And so that's where the unsubstantiated stuff comes in, because it helps us to determine whether or not there's Monell liability.
All right, thank you. Thank you, Mr. Chairman. Thank you, members.
Thank you, Senator. Thank each member of this panel for your testimony. Thanks for being here, and you're excused.
Thank you.
Thank you each for being here. We do have a resource witness from the Texas Commission on Law Enforcement. Chair calls Gretchen Grigsby, who will be able to answer all of our questions and help us make sure we have the right baseline knowledge. Thanks for being here. Introduce yourself, tell us who you represent, and then we're going to have some questions for you. Welcome.
Yes, sir. Good afternoon, Mr. Chairman and members. My name is Gretchen Grigsby. I'm the Director of Government and External Relations for the Texas Commission on Law Enforcement. And I certainly hope I'm able to answer most, if not all, of your questions, because the sunset process is one that I've been living for about 5 years now.
Thank you for that and for being here. We'll recognize Senator Perry.
Thank you for being here. I hope you can answer them. And is my recollection somewhat familiar, and was it accurate?
Absolutely.
Okay, so a couple of things. Where we were at prior to any of the conversations for multiple sessions was there really wasn't any transparency, and there was no requirement that an HR person would talk to the previous HR person regarding, and it could be chief to chief, about the G file. Or there might have been a requirement to have a conversation, but they didn't do anything with it, one of the two. Talk first about the F5, is that what it is?
Yes, sir.
Did y'all change the F5 report to be more detailed? First.
Thank you, Senator. So the F5 has now actually been replaced by a mere report of separation. So no longer do we have the categories of honorable, general, or dishonorable, but instead what you've done is actually made a more comprehensive process that requires a much more detailed list of what a law enforcement agency should receive and review in order to hire a law enforcement officer or one of our other licensees. That includes the background confirmation form that was passed actually in the 87th legislative session through Senate Bill 24 that ensures under penalty of TCOL disciplinary action and up to and potentially including disciplinary action of the chief administrator's peace officer license, that they have reviewed all of the documents provided to them by the previous law enforcement agencies, each one of them, for every law enforcement hire that they make.
And that report would detail in great detail, I remember this conversation, everything good about and everything bad about, nothing left out.
Absolutely, Senator. So in fact, in the bill that's before you, under 1701-45351E1, that is the explicit requirement that the misconduct investigations, any allegation of misconduct against a licensee, regardless of whether they leave that law enforcement agency under whatever circumstances, is concluded, and a summary report of that investigation is submitted to TCOL within 30 days of their separation.
So practically speaking, I do something, I quit, you're going to go out and do the full documentation regardless of the fact I'm no longer there.
The law enforcement agency that was employing them is required to complete that.
And the person reviewing for potential hire, if they choose to hire me and something bad goes on and it's in that particular report of a recurring theme, that person's taking that liability and responsibility on.
That's correct, Senator.
Okay. Secondly, you heard the conversation. This law came into effect 30 days ago. Would it address the concerns of Mr. Grissom in that, let me back up. Basically, today, could there still be unsubstantiated claims reported to the press, if not but for this law?
So if I can address
Sure.
a couple of things real quick. So the requirement that a misconduct investigation be completed and a summary report submitted to TCOL actually took effect last September, and we have been receiving those. The scenario that Mr. Grisham laid out regarding an officer leaving to escape bad conduct, that previously, prior to the sunset requirements that went into place last session, previously, yes, that could have happened. But now today, you cannot just leave to try to escape bad conduct. That must be, the investigation must be completed and submitted to TCOL.
So let's talk about the concept of this bill.
Yes, sir.
It wants to not necessarily hide or anything. It's just not wanting things to get out that are biased or prejudicial before they're unsubstantiated. But in this current system, if I quit and the report's done, that would be subject to Freedom of Information Act.
Under the current scenario for a law enforcement agency that is not subject to 143 of the Local Government Code and Civil Service Protections, theoretically that could be released to the public, yes.
If this bill's passed, would that information be available?
If the bill passed, that information would go into a department file, which would then no longer be available for public information requests.
So, first of all, I don't think there's anybody who's not a huge supporter and fan. And this conversation gets, when you lay something out through Sunset and other places, you just assume that everything's going to get cleaned up. Why would y'all protect something that has been substantiated through internal investigations, literally keeping someone from being hired going forward? I'll put it this way. If it's substantiated and I'm a good guy, why not let it loose? If it's substantiated and I'm a bad guy, why wouldn't the public need to know that?
If it is substantiated, then it is already public and should be. And that the information in this bill, the legislation before you does not change that.
So qualify that. How is something that's in an internal report that reports everything that I've done, good and bad, that could keep me from being futurely employed, public knowledge?
So let's differentiate really quickly. You hear it called in terms of the A file and the G file, or the personnel file and the department file. The personnel file contains everything good and everything that is substantiated that is misconduct. What we're talking about here is the unsubstantiated information.
And in context, is that what used to be referred to the G file that's unsubstantiated, but over here for internal review, but not for public because it wasn't proved?
Correct.
But there is a personnel file that'll look just like that G file on everything that was proved.
Correct.
And that's not prohibitive from someone getting access to it, a CJ?
Absolutely not.
Okay, thank you.
Thank you, Senator Perry. Senator Birdwell, and we have a few minutes before the Senator has to gavel in, so we may have to bring the resource witness back, but go ahead. And thank you.
Thank you, Mr. Chairman. Is there any report that TCOL collects from every law enforcement agency in the state annually, whatever it may be, that chief of police of town A says, I've received this many reports, this percentage were substantiated, this percentage was not substantiated, and when you look at total number of officers, again, size of a small town versus a large town, that you can draw any statistical, maybe not conclusions, but assumptions, that we have a structural problem with too many unsubstantiated? Is there some mechanism you have for some statistical review and analysis across the state in the same way we have statistical analysis across education and other fields?
Senator, I don't know that there is at this time. However, with the information that TCOL will now be receiving post-sunset, I think we will be getting closer to something like that where we might be able to put that information together. But there is not a statewide recording at this time that would give you that kind of analysis.
If I've got a department with 50 officers over here, 50 officers over there, and I've got 207 unsubstantiated over here, but only 3 unsubstantiated over here with the same operational tempo, things that make you go, kind of thing. And so we've got to have some mechanism for y'all to do some review and analysis.
I think with the information we're going to be receiving, we can get closer. I don't know that we can get quite there, but we will certainly get closer to that.
All right. Thank you, Mr. Chairman.
Thank you, Senator Birdwell. And do you mind sticking around? I apologize. The committee's going to have to recess here in a moment so that the Senate can come in, but it won't be long, and we'll be back. Do you mind sticking around a little bit longer?
Yes, sir, I'd be happy to.
Thank you very much. You're excused for now, then. Thank you. And the Senate Committee on State Affairs will stand in recess, subject to call of the chair. For those participating, in a moment, the Senate will gavel in. There's not a whole lot of business to do that I'm aware of. So committee will be back upon adjournment of the Senate or final recess of the Senate, and we'll make an announcement as well. So for those waiting to testify, I apologize. We'll be back, and I don't think it's going to be all that long. So with that, Committee on State Affairs stands in recess up to the call of the chair. Good afternoon. Committee on State Affairs will come to order. As a matter of pending business, Chair lays out Senate Bill 14. Call Gretchen Grigsby. There she is. Ms. Grigsby, welcome back. We were a little bit rushed earlier and want to make sure that this bill gets the attention it deserves and each witness is heard from and want to benefit from your experience on this. And so once again, please tell us who you are and who you represent.
Yes, sir. I'm Gretchen Grigsby, Director of Government and External Relations with the Texas Commission on Law Enforcement.
Thank you. Senator Perry.
So I wanted to, on the record, I want it for clarity 100%, so all that forget or don't know we were doing this today. I'm going to sum it up the way I understand it. You correct me if I'm not. For practical conversation, there are 2 files. One is a record that attaches to the personnel file and is always publicly available.
Yes.
And will move with that officer with all the good and bad substantiated wherever he goes.
Yes.
And is required by the department looking at hiring that individual to be reviewed.
Yes.
There is a secondary file, which has always been in existence that was never really made a public, called the G file. That file still exists, but it's only unsubstantiated stuff that's in there.
It is unsubstantiated allegations of misconduct or basically any other types of files that are not explicitly in the statute included in the personnel file. So the A file.
Give me an example of what other information that's not specifically, what would that include?
Oh, and of course, it's been a long day. And
Let me ask it this way.
yes.
Is any of that that's in addition to unsubstantiated problems, stuff that would end up on a personnel file if they were, this is not, is this personnel information like vacations and stuff we talked about? What is that?
So let's talk about what's in the A file. And so that is any commendation, any substantiated misconduct, or periodic evaluations. All of the other stuff, your background investigation, any unsubstantiated misconduct, those are the kinds of things that you would see in the department file or the G file.
Okay. And this is all as of the new law, which you said September 1 was one component and now June 1st, the rest of it.
So yes, so September 1st, we started collecting misconduct investigation reports from law enforcement agencies because there wasn't a method in place. So the sunset implementation process has been in phases. Of course, we had the launch of the public license lookup, which I think has been a really important component for public transparency. You can now look up any officer and the status of their license. September 1st was also the rollout of that misconduct investigation report. Then June 1st was the agency standards. So all of the things that law enforcement agencies are required to have in place, that was one of the items that was June 1st. And then the personnel files will ultimately be submitted to TCOL for placement in the confidential statewide employment database. We're still rolling out the IT component of that, and so we expect that to happen early next year. But for the time being, we're asking agencies hold those and handle them like you have been and transfer them to the law enforcement agency that's looking to hire your former employee through the TCOL Secure Share system like we have been. They just aren't submitted to TCOL for us to hold at this time.
Today,
Correct.
if I do something bad as an officer, it will be documented, it will be substantiated, and then it will be attached permanently.
Yes.
The G file, TCO keeps that. TCO has the G file,
The agency has the G file.
or the agency.
Yes.
So the agency has the G file, and they are required to look at that.
Yes.
Now, are they also required to have conversations with the next department if there's a trend but unsubstantiated?
Yes.
So all those communications are in line by statute, they're required.
Yes.
All right, thank you, ma'am.
Yes, sir.
Thank you for your testimony. Senator Bardwell, any other questions for the resource witness?
I do. One question, Mr. Chairman. In the bill, it says that it grants hiring law enforcement agencies the right to view the contents of a candidate's department file and requires an agency to provide file contents to TCOL in one of either two ways. Completion of administrative review, which is submitted to TCOL, or upon TCOL's request during an ongoing investigation. Is there a particular criteria that TCOL uses to decide when to ask for those files? Or, no matter what you're investigating, do you ask for those files?
I don't want to speak in blanket statements, but I think it's safe to say that if we were conducting an investigation on one of our licensees, we would request any ongoing misconduct investigation or any other item that's in there.
Whether it's a de minimis investigation or there's no threshold at which you would say, if it's this and below, we won't ask for it.
Perhaps not if we're looking into non-compliance with training requirements, something like that. But if there were any allegations of other violations into our rules or statute that are within our purview, we would want to look at that.
Because what I'm driving to, the reason I like this is that way it's a check on that file.
Sure.
That, I don't want to say you're disinterested, but you are disinterested in the fact that you didn't generate the file, but you are interested in that you're reviewing it. Providing a third set of eyes is not, that was not part of the process of putting it in that file.
I would agree with that.
Therefore, I think it's appropriate for you to look at anything
Yes, sir.
short of the example you gave.
Sure.
Okay. Thank you, Mr. Chairman.
Thank you, Senator Bardwell, and thank you for your testimony. Thanks for being here. Reopening public testimony on Senate Bill 14, called Juliet Thurber, Charlotte LeMay, Melody Tremalo, Emily Gogol, and Deputy Jason Warren. I call Kathy Mitchell. I saw Ms. Mitchell earlier. There she is. Amanda Tomas. Elizabeth Miller. Okay, and take your time coming down. We'll get you on the next panel. How about Jim Crosby? Looking for Jim Crosby. Still here wishing to testify. Peter Hunt. Or we'll get started, and if someone else makes it, they can take that seat. Pardon me. Ms. Mitchell, welcome. You remember to get close to that microphone, introduce yourself, and go ahead.
Thank you, members. I would like to start with something that I believe is a completely unintended consequence, but very significant in the way the words on the page of this bill are written. This bill does not mirror the language of 143-089G, which creates the sealed personnel file. In fact, this bill does not use the term personnel file. It uses the term departmental file. The reason that this matters is that courts have interpreted the scope of what can be placed in the secret personnel file as being personnel information related to the employer-employee relationship. This is foundational law that has been used to interpret how the Public Information Act authorizes the release of information by police agencies since 2000. This is a case called San Antonio v. Express News. Under this case, only certain information is placed in the personnel file, and things like body camera footage, 911 call audio, generally the kinds of things that the Uvalde families have been fighting for the past 3 years, are not in the G file. This bill, unfortunately, states that what will be in this new file is any letter, memorandum, or document relating to the license holder. I want to pause on that for a minute. Let's think for a moment about a small agency that's run by a constable of himself. There are many constable agencies of one, more than 300. Does this mean that the constable can close all the documents at his agency? I don't believe that was the intent, but that is what the words on the page actually say. If you have a sheriff's agency with 2 people in it, do all of them together get to decide that they're going to close all documents related to themselves? This is not how this should work. Voters should have access to basic information about elected officials, and we believe that this is going to impede that. So I have a handout. I'd love for you to take a look at the side-by-side G file versus what this bill says.
Thank you. The gentleman behind you will take that, and we'll make sure and see it. And he's coming around to help. There we go. And thanks for your testimony. Welcome back. Introduce yourself and go ahead.
Hi, Emily Gogol, representing Self, testifying against. If you've never been unlucky enough to end up on the other side of a police investigation and the other side of police misconduct, let me explain to you what that looks like. When I was working as a news reporter in a different state, I was investigating police misconduct in the case of several murders of unarmed Black men that happened across the state. During this investigation, we were using completely legal methods to find all of the information that we had, including PIA requests, to find personnel files so that we could link several cases back to one officer. Everything that we reported on was legal, all the ways that we obtained information was legal, and all of the coverage that we did of this case was fair, balanced, and had accurate reporting sourced from the videos that we found. This was still a lengthy process. It took a very long time, and it put me and my team at significant personal risk. If you don't know what it's like to be harassed by law enforcement, let me tell you what it's like. It's very scary. You're never sure if you're safe. You don't want to drive around at night. You get scared when you're driving or walking past plain white cars. You don't call for help when bad things happen, and you don't want to go to work at night because you know that a police officer is going to be sitting in the parking lot to yell at you as you're going into the building alone after dark. This is a very scary thing that happened. Most of my team only stopped getting harassed when they moved out of state. This bill has a chilling effect on reporters who use PIA claims to get information regarding personnel files. If I'm arrested and charged with a crime, that arrest report is immediately made public. Why do police get to go ahead and be accused of misconduct and have those reports not shared with the public? If we're all going to have our arrest records shared with the public, police should also have misconduct records shared as well. Accountability is only scary if you're not acting up in a way that stands up to scrutiny. Cops in this country don't have to know the law to to enforce it, according to Supreme Court in Hain versus North Carolina. So when they violate the law, the only way for us to hold them accountable is for us to be able to find these records, these personnel files, these things that you want to keep secret in these bills, and use them to bring justice. Don't make it easier to get away with abuse. Make it easier for Texans to demand the best from our police officers.
Thank you for your testimony. Welcome back. Introduce yourself. Go ahead.
Howdy, my name is Melody Tremalo. I'd like to read an excerpt from the passage of the bill. Except as provided by subsections D, E, and F, a law enforcement agency may not release any information contained in a license holder department file to any other agency or person requesting information relating to the license holder. Subsections D, E, and F, to paraphrase. Subsection D, a law enforcement agency hiring a license holder. Subsection E, a commission as part of an ongoing investigation. And subsection F, a law enforcement agency if the disclosure is permitted under a meet and confer agreement made before September 1st, 2025. Further, the bill states, a department file maintained under this section is confidential and not subject to disclosure under Chapter 552 Government Code. That's the law that allows the public the right to request and access government records. So, to summarize, this law, to a sentence, you want to protect police from accountability. You don't care about responsible policing, you care about carving out exceptions and removing liability from the people who should be held to the highest standard possible. Even if law enforcement agencies were capable of proper internal accountability, you do not open those doors. You do not give them the broom to hide their dirt. What is the phrase that I've heard from multiple law enforcement officers? If you have nothing to hide, you have nothing to fear. So what do you intend to hide with this bill? I'll tell you. The use of force, officer misconduct, police brutality, discrimination, sexual coercion, and on and on and on. You can look at any news article out today and find multiple instances of police misconduct across multiple agencies. And if it somehow comes to light, let's look at the language from the bill itself. Any letter, memorandum, or document relating to alleged misconduct activity by the license holder. That's what you're hiding. So what do you have to fear? Being held to the same standard as the people you lord over. You know that that standard is unacceptable. It's why you author and endorse bills like SB 14, to protect yourselves from the culpability that you owe the general public and a free and fair society for all, not just the privileged few you think should access it.
Thanks for your testimony. Welcome, introduce yourself. Go ahead.
My name is Jason Warren. I'm the Chief Deputy with the Walker County Constable's Office.
Get a little closer to the mic so we can hear you.
I'm a short guy, so that happens. Again, Jason Warren, Chief Deputy with the Constable's Office in Walker County. That's the Huntsville area. About 25 years law enforcement, a lot of that spent as a law enforcement administrator. Specific to this situation over here, I was on the TCOL advisory board that drafted the model policies that pushed out to all the agencies that we've talked about previously today. This piece of legislation serves as like the final piece of the puzzle in order to protect the law enforcement officers across the state of Texas, their families, and protect the integrity of the law enforcement agencies that are charged with keeping people safe. One of the things that I wanted to address is to make the committee aware that any type of misconduct is now mandated to be investigated, and if it's substantiated, it's reporting to TCOL. This bill has nothing to do with any type of allegations that were substantiated. This has to do with false or unsubstantiated allegations. That coursework or that work that the agency would do to determine whether or not there was any type of fault by the officer would be documented in this file. And it's just designed to, make sure that the record reflects the fact that the officer did not commit the allegation that was alleged. I think it's imperative to pass this piece of legislation to solidify the legislative support of the good men and women that protect our streets and serve and protect the public every day.
And thank you for your testimony. Welcome, introduce yourself, and welcome back. Go ahead.
Good afternoon. Thank you, Chairman. Thank you, committee, for your time and attention today on this matter. I'm speaking in opposition to this bill. I'm really, really worried about it. I am a resident of Tarrant County. I'm represented by Senator Parker. I want to tell you a little bit.
We know you, but go ahead and say your name officially on the record.
I thought I did say I'm Elizabeth Miller and in opposition of the bill.
You probably did, but I didn't catch it. Thank you. Go ahead.
I'm happy to say it again.
Right.
I still don't like it. I'm still Liz. I am from Tarrant County, and we do have a jail death problem there. Perhaps you've heard. I know, just to give you some context, we've had over 70 deaths since the current sheriff has been in office. And to give you some context on what that means, people are familiar that Harris County has had some problems. We had as many jail deaths in Tarrant County as Harris County did last year, without nearly as many people. And to give you more context, Collin County had none. And we've been, in Tarrant County, the residents across the political spectrum have been worried about this and wanting to have a little more oversight and transparency on what's going on. We're assured it's just a chronic illness problem, but if that's so, we need to explore that too. These are legally innocent people, most of them, and it's our responsibility. I hope the committee agrees. Once we take them and incarcerate them, we're taking on the task of keeping them safe. And so Tarrant County residents want to know more. One of the people that died, he was arrested on Christmas Eve. His name is Mason Yancey. I wish I could mention all the 70-something people, including the baby that I'm not sure is counted because the baby was born on the floor of Tarrant County Jail and died. She wasn't in custody, so I don't even know if she's in the numbers. And the numbers keep going up. Tarrant County forgot to tell us about one that they're legally required to do this spring within the 30 days. They didn't. One of the people who died is Mason Yancey. He was arrested on Christmas Eve. Within 2 days, he was dead. Mason was a diabetic. He did not get his insulin. At least that's what we think happened, but we don't really know. And so he was a Second Amendment activists. So all the CJs and whatnot of the world are down there paying attention. And so now there's the county commissioners and the residents of Tarrant County, and we're getting more and more separated. The county commissioners have instituted a new comment policy. They're arresting us for clapping in there. We're paying off settlements, and the citizens get more distant from the government with lack of transparency. I have a lot more concerns I wish you guys would ask about and talk to us about. I'm worried about a lot more of my lawyer brain thinks of a lot more problems for prosecutors preparing for trial. I could give you a lot of problematic examples under this bill. RLC does not
Thank you for your
I
testimony.
have sheets from them on that.
Senators, any questions for any of our witnesses on this panel?
Who do I give?
Lady behind you will take that and make sure we get it. Thank each of you for being here. You're excused. Thank you for your testimony. Called Jim Crosby, Peter Hunt, Lakshmi Fox, Paige Williams, Robin Foster, Eric Martinez, welcome to each of you. We'll begin over here. Since you're on the end, you got to get close to that microphone. Introduce yourself and go ahead. Welcome.
I'm Jim Crosby, founder of Nonviolent Austin and representing myself and Nonviolent Austin. Thank you. Good afternoon. Thanks for the opportunity to speak, in my case, in opposition to SB 14. I'm here to talk about a crucial bipartisan agency here in Austin that would be negatively affected if this law passes, an agency called the Office of Police Oversight, or OPO. The City of Austin created the OPO in 2018 to build trust between the police and the community. The office accepts community feedback about interaction with the police, conducts independent investigations, and makes recommendations to the police department and the city manager. This foundation of transparency and community involvement conveys that the department is conscientious, professional, and most importantly, has nothing to hide. Further, when investigations reveal that most officers are good and misconduct is rare, the OPO has the power to change negative perceptions of police. For example, one OPO investigation from this summer revealed that part of a complaint was invalid, supporting a more positive view of the officer and department. Oversight committees like the OPO can also save our local government's money by catching problems early before they escalate to expensive lawsuits. And finally, agencies the department in line with modern policing standards and improves officer safety. So as you can see, oversight agencies like Austin's OPO provide essential services to the community and to police departments, building trust between the two and increasing safety for everyone. If this law passes, the OPO would no longer have the information it needs to achieve these goals. Please don't pass SB 14, which would significantly hinder such agencies from fulfilling their missions of making our communities safer. Thank you.
And thank you for your testimony. Welcome. Introduce yourself. Go ahead.
Good afternoon, Senators. My name is Peter Hunt. I'm here representing myself, speaking in opposition to SB 14. I'm actually here to speak about a different organization in Austin, the Community Police Review Commission, which receives some administrative support from the Office of Police Oversight. Unfortunately, SB 14 would effectively dismantle the Community Police Review Commission. The commission was established very recently, just last year, and I've been attending its monthly meetings basically since its inception as an observer, and so I can attest to its function and intent. The CPRC is a local oversight commission dedicated to transparency and ensuring that community recommendations are a part of the discussion of police activity. Their primary function is to review cases of police conduct after an investigation has already been completed. They may do this either on their own initiative in response to a pending complaint or at the request of the department. Upon reviewing a case, they provide a recommendation based on their findings and can provide similar non-binding recommendations regarding training or documentation. The CPRC commissioners are fresh to their jobs, eager to do their work, and I am personally really hopeful for what this commission can achieve for the city. It's not an anti-police body, rather it's a non-partisan commission that aims to ensure fairness and trust and whose members comprise a very broad range of perspectives and a diversity of viewpoints. Distinct from Austin's Office of Police Oversight, which is composed of city staff, the CPRC is made up of volunteers from in the community who have been randomly selected from among qualified applicants. The commission has impressed me as serious-minded and judicious. They have been proactive about endeavoring that they hear from the department, its chief, as well as from community members. It's really, in my mind, a wonderful example of municipal voters deciding how best to ensure transparency, accountability, and strengthen trust at their local level. Unfortunately, SB 14 would effectively end this. The commission is an outside agency that would be barred from accessing many of the files related to police conduct essential to their function. In my mind, this is an acute example of how the bill would hinder transparency and accountability. Happy to answer any questions.
Thank you for your testimony. Welcome back. Introduce yourself. Go ahead.
Hello, my name is Eric Martinez, and I'm the Executive Director of Mount Amiga Action, an organization based in Hays and Caldwell County. I'm here today because Texans believe in responsibility, transparency, and the principle that the government answers to the people. Senate Bill 14 would create a new department file with any document relating to an officer or jailer in Texas, and then seal it off from the public entirely. That includes body cam footage, 911 audio, internal communications and complaints, even those involving serious harm or death. What's most alarming is this. SB 14 would undo recent rulings by Texas courts affirming that these records must be released under the Public Information Act. After years of delay and legal battles, appeals court ruled that families, the families of Uvalde, have a right to see the documents that reveal what really happened. This bill would throw all of that out. It would override hard-won legal clarity and make it legal for departments to permanently hide those same records from the public, no matter how significant the case or how severe the consequences. If this bill becomes law, future Uvalde families will never see the footage. Depending on how quickly this passes, Uvalde families may never see the documents that government has fought to keep away from them for years. Parents will be told to trust the system while the facts are locked away. Let's not forget, in hundreds of departments across Texas, some with only one officer, this bill would let officials seal their own records without independent review. That's not local control. That's a lack of oversight. Voters will not be able to hold elected officials accountable at the ballot box if all documents are sealed. We are a state that values truth, not cover-ups. We believe in backing those who serve honorably, but that starts with accountability, not secrecy. SB 14 is not about protecting public servants. It's about shielding institutions from public responsibility. I respectfully urge you to reject this bill and stand with the families of victims and every Texan who still believes that public trust is earned, not hidden.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Yes, my name is Paige Williams. I am here representing Dallas County Criminal District Attorney John Crusoe, and we are on this bill. The policy behind it makes sense. It's fair. We have an entire group of law enforcement agencies under the Civil Servants Act, or under civil servant rules, that that the other agencies, specifically Dallas Police Department, are not under. Bringing those more in line makes sense policy-wise, and on that regard is one of the reasons why we're on the bill. We have a little bit of concern with some language. It is part of the amendments that were added at the, I guess, on the floor when y'all added the amendments during the regular. They're in section F of the bill. We believe that those two sentences need to be in two separate sections because the way they read, it appears as if it is restricting the Michael Morton. The second sentence appears as if it's restricting the Michael Morton Act, and we certainly don't want to harm any criminal cases where this information would be relevant. Additionally, where we agree with the policy behind it, this bill as written doesn't entirely match the civil servants rules. And we would like a little more parity with that because under the G-file rules, which is what y'all have been talking about and what is the civil servants rules, the exceptions are as otherwise provided by law. They're not specifically the Michael Morton Act and the Sandra Bland Act. It covers a lot of things that aren't covered under the bill currently as written. That includes legislative investigations. It wouldn't be covered under this where the civil servant rules would be included, like they would be, it would be covered. So we would like that language to change if possible. We don't necessarily need it, but we do need F separated, please.
Yeah, we'll probably have some questions for you too. Thank you for your testimony. We're going to keep moving for now, but don't run off, please. Welcome. Since you're on the end, you got to get close to the microphone. Introduce yourself and go ahead.
Thank you. My name is Robin Foster. I'm with the Harris County Deputies Organization, Fraternal Order of Police Lodge 39. We represent law enforcement agencies in Harris County, to include the Harris County Sheriff's Office. I am also joined in the statement by Ray Hunt of HPOU and Michael Bullock of the Austin Police Officers Association. HCDO FOP 39 has registered on the bill because of concerns regarding the unintended consequences of disclosure of department files under subsection F for peace officers. SB 14 creates a mandatory requirement for all agencies to keep a separate personnel file that will be called the department file. This file shall contain all allegations of misconduct by the officer that were investigated but resulted in no discipline due to insufficient evidence. It should be noted that an unsustained complaint against an attorney can only be kept for 180 days, and for a doctor for 5 years. For a police officer, unsubstantiated complaints are going to be kept forever. SB 14 is very similar to requirements in Texas Local Government Code 143.089, that allows municipal police agencies that have adopted meet and confer under 143 to maintain a department file. Here, SB 14 seeks to broaden this concept in 143 by making department files mandatory for all law enforcement agencies. But unlike 143, there's no mechanism to bargain for protections of the individual employee. For example, in HPD, the Houston Police Department has 143 meet and confer. Part of their contract between HPD and the City of Houston is to give protections to officers when their department files are requested under 3914, the Michael Morton Act. These protections do not seek to hinder irrelevant information from being given under 3914. What it does is protect the other things that are in the file that are not relevant to the criminal case from being disclosed to prosecutors and defense attorneys. It gives a process, and we've outlined this process in sample language as that's in the handout. Thank you.
Thank you, Deputy, and I think we're probably going to have some more questions on this. Thanks for giving this to us. I've got some questions, but I'm going to yield to the panel. Senator Perry, you had your light on. Well, thank you so much. I want to Is it deputy? I know you represent the organization. Is that the, may I call you deputy? Is that your title? I don't want to mess it up.
No, sir, I'm an attorney with the Harris County Deputies
Okay,
Organization.
I gave you a promotion. I'd love to be a deputy too, but thank you. So I'm going to go back to this other lawyer next to you for just a moment, the prosecutor. Thank you for being here as well. I was making some notes. There's some really smart people in our offices watching this and taking everything down, but I don't want to miss anything. Are you comfortable giving us something in writing on the specific concerns you raised on behalf of the DA? Do you mind doing that?
Yes.
Not right now, but if you don't mind, it would help us. I was going to ask you about that.
Is it okay if I email Dylan, because he's the one in Senator King's office that I've been working with?
Oh, of course, that'd be great. Just so, of course, and we just want to make sure. I want to make sure I don't miss it, and then counsel on behalf of the deputies. And it sounds like you're also speaking on behalf of the Houston and Austin City Officer Associations. Is that what you said?
Correct. They join in support of this language.
Okay, thank you very much. And so you were explaining, you were also in the same section as our prosecutor friend, but it sounds like your concern is different. Did you get cut off? Anything we need to know about that?
Yes. So this seeks to create some protections for the individual, and it's not to not have relevant information be given under 3914, but it's to protect everything in the file. So without these protections, a 3914 request is made by a defense attorney. Then the file is given to a prosecutor who will go through the entire file, take out what is relevant to give to the defense attorney. In Harris County, because HPOU has a contract, what they have is they have an attorney within HPD who, anytime one of their files is requested, they go and ask for an in-camera review by the judge of the file, and the judge will decide what needs to be taken out for disclosure under 3914. That keeps the rest of the file of things that do not need to be disclosed under 3914 protected from the not only the defense, but the prosecutor's office. Because if the prosecutor sees the information that's in the file, they then have that information under 3914, and it will go into their database. So these are unsubstantiated claims. If something is substantiated, then that's going to be in the personnel file, which is subject to open record. But what we're trying to do is protect unsubstantiated claims, because these could be very claims that are basically defamation of character, false claims, lies against the officer, that the officer is going to carry forever under this law. Unlike attorneys and doctors who only have to carry it for so long, officers have to carry it forever. So this allows this that's supposed to be confidential to remain confidential. And it's very similar to, let's say, medical records or CPS records that have the same provisions of protective orders and in-camera review.
Thank you. Let me ask you how that would apply. You mentioned that in Houston there's a contract. I guess that means between the union representing the officers and
the city of Houston.
The city, yes, ma'am. So then in an agency in Texas that did not have such a contract, there's a request under 3914. What would happen to the information you just described?
It really depends on the agency. So I represent small agencies and large agencies. So the large agency I represent is the Harris County Sheriff's Office, very large agency. And our hope as the union would be that they would also send a lawyer to protect the records, but it's not mandatory. And it's not something that's going to be done consistently. What is most likely to happen is the file will be requested and the prosecutor will be given the file to then parse through, like they do in personnel files, which are the ones that have substantiated claims, and look for evidence that needs to be given. Now, Harris County DA's office is very large. They have a whole unit that does these 3914 requests that keeps their internal databases. So it would be something that would be for that unit to keep it out of their because once they have it forever.
Thank you. And Senator Shorten was talking about the Michael Morton case earlier, and obviously we're all familiar with that. And so if you'll allow me, everybody probably gets this but me, but there's the general concept of Brady material, exculpatory evidence. The Morton Act is broader than that, or it's just the Texas version of that? Help us understand that.
Yes, and I'm sure you can even
Please, both-
further into it.
please, y'all go ahead.
Because she practices criminal law more than I do. Of
course.
But there's a difference between the pretrial discovery, where just like in any other law, you're going to get a lot more than what is relevant to be admitted into court. So when we talk about exculpable evidence, that is something that's going to be relevant. 3914 is a bit broader, but also there's going to be a lot of stuff in this file that even if it's an unsustained allegation, is not relevant to this case. And so the in-camera review by the judge, who doesn't have a fight in the case per se, would be the one to choose what would be taken out, which is a system that is working for HPD officers that we'd like to broaden for the state as a whole. Now in Harris County, you go judge by judge, it may be different what they take out, but with the protective order, that keeps it from being given to the defense bar as a whole or to the media or anything like that.
Thank you. And when the judge, in the situation, the setup that we have in Houston with the contract, when the judge is going through that analysis, is the judge determining, is this information exculpatory? Should this be given to the defense? Is that the only question, or is the judge weighing the exculpatory value against the potential harm to the officer? Help me, if that makes sense, help me understand what the test is.
The language that I provided is the standard would be relevant evidentiary material. So it'd be what was relevant to the case at hand, and any information that'd be relevant for the case at hand. Now there could be certain cases where things are going to be much more relevant, where you're going to get a lot more information, such as a murder trial versus a theft trial, right? But it gives the judge that discretion, and if the judge is making a decision, that's something that can be watched on what is given, but also if the employee wants to send a lawyer to fight that or to appeal that or to try and get their own protective orders, they could use that mechanism if they want, but they don't have to.
And so I understand the distinction you drew. We might say in a civil case, there's the scope of discovery, which is broader than actually relevant admissible evidence. Is that the idea we're talking about?
Yes.
The concept?
So the information that's given under 3914 may not actually be admissible in court. So the protective order specifically said that it cannot be disclosed outside this case, except if it becomes admissible in court, because then it's a public court hearing.
Okay. And so then one more question about the protective order, and thank you for holding my hand through this. This is a process that I'm not specifically familiar with. With this procedure is put in place that you described, if there's information that under 39, under the Michael Morton Act should be disclosed, it's either relevant or calculated to lead to relevant evidence, admissible evidence. Would that still be disclosed, but under a protective order, or would it not be disclosed?
It would be disclosed under a protective order to keep it within that case. So now what we have, I can only speak in Harris County. So if a defense attorney gets 3914 discovery and they find something juicy on an officer that they see a lot, it gets posted on the defense bar chat on, look at what I got about officer A, B, and C, when it's unsubstantiated claims. This is different than something that there has been shown evidence of misconduct and an officer gets disciplined. That's public record. But so this is just unsubstantiated claims with any profession. When something is investigated and it's unsubstantiated, then it is in this department file, even though officers are unique in that they have to hold it forever now.
Thank you. And to make sure I'm clear, under the system you have with the City of Houston Police Department, that type of information would be disclosed if it were covered under the Michael Morton Act, but subject to a protective order and not going into the database. Did I get that right?
Correct.
Thank you.
And this also is disclosure under the Sandra Bland Act as well.
Thank you. Thank you. Ms. Williams, do you know if there's I'm going to ask a bad question, and you just answer the question that I should have asked, if you don't mind. But is there a system like that y'all use in Dallas County? Does it depend on the department? If that question makes any sense.
So we don't use the same system.
Okay,
So
please go ahead. How do y'all do
correct
that?
answer to that. But when it comes to 3914 and criminal cases, and y'all have heard a lot of testimony about the civil side,
And get a little closer to the mic, please.
you've heard a lot of testimony about abuse of office, the excessive force, excuse me. The more civil side of this issue.
Yes.
But when it comes to a criminal case in 3914, it's y'all's job, and y'all are going to have to weigh whether a law enforcement officer's job, personnel file, is more important than the life and liberty of a defendant. And that's a question that has to be asked at some point here, because that's the way the civil servant rules are set up, and that's why we have G files. Because at some point, the other question, now that we have Heath, the opinion in Heath, that has to be decided is who is going to make that determination. Is it going to be the prosecutor, or is it going to be law enforcement officers making the determination of what is relevant, exculpatory, or mitigating in a case? The other issue that y'all also need to address in this, or think about at least, is that when it comes to a law enforcement, an officer, they don't just handle one case. They handle thousands of them over their career. And if there is information that the prosecutor has their hands on, under Michael Morton, we have a continuing duty to disclose, which means we have to disclose that information to any defendant who was ever associated with that officer. So restricting it or putting under a protective order or anything like that, and at least in my opinion, would violate the Michael Morton Act, and we would probably change our position on it. Right now, as written, it's not ideal. It's okay, and we can live with it if you separate the two sentences in F, and we can work around it. If y'all want to address the issues that we discussed, what you would probably want to do is, I'd actually have to think about that.
Thank you. Oh, I didn't mean to cut you off. Go ahead.
No, I couldn't. I'd have to think about that.
problem.
Put something more in writing. If y'all wanted to go that far.
If I may ask, and I ask your forbearance and the witnesses and the members of the committee so I can understand this. So setting aside this bill for the moment, current practice, there's evidence, there's information that under the Malcolm Morton Act you believe is triggered, but it's unsubstantiated, there's a problem, there's a concern about harm, legitimate concern about harm for the officer. Would that be disclosed subject to a protective order, or would the Michael Morton Act trump that current law without this bill? This isn't a test. I want to understand where we are, if you don't mind. And if that question doesn't make sense, you tell me.
No, it makes sense. We don't use protective orders because that decision is made, on our bar cards, which is if we violate the Michael Morton Act, we lose our bar card.
Right.
So that decision is made. And like Houston, we do have a unit inside our office. So not everybody in our office gets to see the G file.
Okay.
It is completely restricted amongst a small group of individuals in our office. And we have to request that information from them as a prosecutor. And then we get what they have written up that has to be disclosed. So we don't even get to see the G file.
Okay.
That information is always turned over to the defense counsel. And as she pointed out, once it's out there, and there's no taking it back.
Thank you. Counsel, did you have something else to add?
Yes, and I think one thing that she highlighted was who is making this decision. That's why we propose, like we do in Harris County, where there's an in-camera review by the judge who is weighing what would be Michael Morton material and then keeping everything else confidential. Because as she said, if a prosecutor sees it, they're responsible for it. And so that would keep it, the other stuff that's not Michael Morton, protected. Because that's the stuff we're looking at. It's all that other stuff.
Can I add
Please go
follow-up
ahead.
on that? Under the Heath opinion, the 2.139 in We call it the Richard Miles Act in Dallas, but the Richard Miles Act that we passed, that y'all passed a few sessions ago that said police officers had to turn over all their information to prosecutors, this would fall under it. So we also have that aspect that would need to be considered. Again, though, bringing the officers, the civil servants, and those that are not under civil servant protections in line is good policy. I want to reiterate that.
I realize that, and I may, and if I've gotten a little off topic, I apologize, but this is a pretty important concept. I want to understand it as we get this bill right. Go ahead, Counsel. Anything else on that?
No, sir, unless you have specific questions about
I don't at this point. I think Senator Perry may. Senator, thank you for waiting for me. You go ahead.
Again, not an attorney. The way this bill has been explained, due to TCO reforms that were required through multiple sessions, this is their product. The way it was explained, there's two files. There's always been a G file. Now there's a, quote, personnel file that has all of the sustained, documented, good and bad on the officer's personnel file. Correct?
No, sir.
Not unsustained.
So there's always been a personnel file.
Well,
every agency, even if they don't have civil service, has been keeping a personnel file that has always had your discipline history in it. What is new is now agencies that don't have civil service, including the Harris County Sheriff's Office, now have to keep a separate file of unsubstantiated allegations. So that's new.
So for Harris County, it split your file.
Harris County has split your file. Places like the Houston Police Department, who have had 143 for a very long time, they've always had the G file.
But let's not split it. Here's where I'm going.
Yeah, they've always had the split.
This whole conversation is transparency to the public. You got to have public trust. That's the number one. Public trust is the best thing in the world for law enforcement. And you do that by being transparency where it's justified. So all of the testimony that's come up after the conversation with the representative from TCO has pointed to body cam footage wouldn't be available. So let's talk about that. I guess words matter and it gets so frustrating. Everybody knows what our intent here is. Everybody knows what our intent is. Don't let the bad guys stay and protect the good guys. That's as simple as it gets. So this memorandum that is now going to be attached to what used to be an L5 report, but it's in great detail as to what their offense was and what was substantiated. That's one component of the conversation. Would there be access to the body cam footage that created the substantiation of that report, or is that off limits?
No, sir. So body cam footage, reports, all of that are not part of this conversation because those are part of cases. Like those are part of an arrest or a part of a case. So those are always part of that case file.
Let's back up. If I'm a guy and I do something bad and they write it up on this report now, not a form, but it's now a detailed report of you've done something bad, we've substantiated, and we're going to attach it to your personnel file. Going forward, if I move, that's part of the conversation. If someone gets that file on the other end and say, we see the report, but really, what was it? Give me the body cam. Give me that you wrote your report up. Is that available to the public?
Yes, if it's substantiated.
If it's substantiated. That's what I'm saying.
Things.
Okay.
So there's the stuff that attaches to an individual officer, and there's the stuff that attaches to a criminal case. So let's say, hypothetically, I'm a deputy, and I arrest someone. And in that arrest, I'm accused of using unnecessary force. Well, that arrest has an arrest report, has an arrest case, has an arrest file. All of that body camera footage is in that. And all of that body camera footage is subject to public record once the criminal case is closed, which the officer doesn't have anything to do with that. But the administrative investigation on the administrative, did I follow policy when I arrested this person? That is the only question of what that answer is the only thing that goes in whether it's in the G file or the personnel file. Now, whether I'm criminally liable or civilly liable, completely separate. This is only about whether I'm liable on policy violations in the administration.
Wow, you have just split the baby where it's very clear, and I don't think that meets the intent of what we're trying to do based on colleagues' conversations. And I hate that. You make a very valid point. Individual liberty and public trust is that balance. So the personnel file is strictly related to administration. So if a criminal accusation of excessive force, in our policy, it defines some general parameters of what that looks like, and they can put a yes or no there. And that's what is moving through the file system going forward, because under that administrative, it was substantiated, whatever they used to get that point.
But when we have in Harris County, when we have an allegation of excessive force, there's the administrative investigation. There's also an independent investigation by our DA's office on allegations of excessive force. So the checks and balances are there without talking about the administrative files.
So under my example, administratively, I failed the test. It's now a permanent record for personnel, full public disclosure. The G file now contains that. Well, it really is unsubstantiated, so it doesn't even go in the G file, does it?
If
It would.
if it
Even if it's substantiated, it's still in the G file history. Is that everything?
it's substantiated, it's in the public record
Public, but I'm talking about the support for my decision. Because so here's the deal. If I make a decision that you administratively failed the policy, it could have been my bad judgment that it really wasn't a bad file, but if you look at the body cam, it was either clearly really, really bad or really, really not. So I'm the king keeper at that point, right? Somebody internally made that decision based on what they saw. And to your point, very few people see it. So it's a very closed group that's looking at that review. Fast forward, I don't think there's very many departments that have a meet and confer, or do more departments have a meet and confer process?
Correct.
Which one? The majority have them or the majority don't?
The minority have meet and confer.
So very few people, and I'm going to the protection of the officer's liberty here, very few departments take advantage of a protective order. My questioning to the attorney today was, what we're trying to do is not bias or prejudicial the process through the press before you've been accurately convicted, so to speak. So you garner protection because it's a judicial review, and none of that can leave, as opposed to departments that are naked, I guess, running that way. They don't have any protections for the officers to get the benefit of the doubt, in that they could end up with all their stuff out there and prejudiced a present case.
Yeah, in Harris County, we do see a jury by media a lot.
Oh yeah, no, that's the challenge of today, right? You want to say something? I'm stepping over toes, or on toes, or around toes.
I'm going to hold that thought. No, I don't want to cut this off, but I'm going to get the next witnesses ready, but this is not to chill this discussion. I know you won't forget what you're going to say.
Totally.
So please hold that thought. And Senator Perry, you can ask as many questions you want, but hold tight till we get some folks on deck. So for our next panel, we're going to be looking for Lakshmi Fox, Dr. Susanna Carranza, Mary Elizabeth, Michael Bullock, Luis Soberon, Kirsten Budwine. Lakshmi Fox, Susanna Carranza, Mary Elizabeth, Michael Bullock, Luis Soberon, Kirsten Budwine. Now, are you speaking for Austin because Mr. Bullock has left, or do you know? Is he still here?
No, sir.
All right.
He has other things to say.
Very good. Okay, thank you. Luis Soberon, Kirsten Budwine, and counsel, thank you for letting me interrupt. Please go ahead. I thought you were going to say something.
So just I'm just going to land the plane. Is the administrative failure or success enough for the next HR department to make objective decisions with respect to keeping that guy in the system?
So my answer to that is probably going to be that what is the new F5?
It's the report.
Is the new report. is sufficient. I haven't seen it. I
So
can't-
it's sufficient, we think. Is that sufficient that if the public were to see it, they could go, well, it looks like they did their homework. It looks like they substantiated their opinion as to why this guy's good or bad. Is it something that could give public trust the concept that there's a legitimate review process in place? You haven't seen the report, nobody has, but
Yes, and I mean, I think the system is currently set up in both civil servant and current system is that anything that is substantiated, the public has access to under the public information request. It's those unsubstantiated ones that is where we get into those nuanced levels.
So I don't think that based on what I don't think people want unsubstantiated stuff out there biasing and prejudicing a case. I don't think that at all.
I think that's
Now,
what
I think there's people that would argue against that they want to see it all and then make the decision. It kind of goes back to what we had earlier. I want what I did today on trial, and then all my history of all the bad things I did or didn't do can influence where I get what gets to me. But so substantiated administrative personnel report that follows the individual now instead of the F5, which was worthless, plus substantiated G-file information.
it would no longer be G-file if it was substantiated.
Thank you.
'Cause
So
it would be automatic.
substantiated G-file information will always be part of the administrative review report that is subject to public going forward.
Right, because the minute it becomes substantiated, it's no longer in that G-file, it's moved.
That you just answered the question, and we won't have to do this over and over. So as was presented earlier, if it's substantiated, it's accessible by the public.
Yes, currently.
Even though if it's not directly, I know it's administrative, but I'll go back to, you made a distinction, body cams are for criminal. But if body cam was the reason you're administratively put on file, let's say you didn't turn it on. Let's just say I didn't turn my body cam on and something bad happened. Is that an administrative failing that would be subject to the public, that the guy doesn't turn his body cam on 3 times a week?
Yes, that would be a clear.
That would be a clear administrative function that would be subject to Public Information Act.
Right, and it would probably violate policy.
Okay.
So we have a multiple,
I'm back to where I was. If you do something bad enough to get an administrative write-up that's bad enough to follow you through your history of it, the public can see that, but also if inquired, what is your support for this determination, that is available.
Yes, I can't speak for every agency, but most agencies that I work with have mechanisms where those are kept.
Okay. And Michael Morton Sandbland, that's a whole different lead. I'm just looking for,
He's out west. Or,
I don't want public to have limited access, but I don't want them to have access that are prejudicial and biased and unsustained. Are we there?
right, and that's why we're trying to move the officers that aren't protected under civil servants kind of more in line with those that are, because the civil servants are protected.
This way,
without
With,
this.
with 143.
right?
The civil servants are already protected without this bill. It's the other agencies who are currently not.
Okay. And the bill does that? With the
Not
separation of two?
gracefully.
With the two split, the sentences?
It's sufficient to achieve the.
Well, I'll ask it this way. If there's clarity that you can provide, we want to get this right because we don't want to discredit public trust and we don't want to put good guys in harm's way.
Yes.
So if there's something you can provide other than just splitting the sentence, that you want to go further, you need to, as Chairman Hughes said, get that to the appropriate bill authors conversation and and we'll have the conversation and clarity, because we'll make it work doesn't give me comfort when you are talking about liberty either way.
Right.
Thank you.
Thank you.
We thank each of you for your testimony, and you're excused. Thank you very much for being here. Call Lakshmi Fox, Dr. Susanna Carranza, Mary Elizabeth, Michael Bullock, Luis Soberon, welcome. We'll start over here, so get close to the microphone. And yes, ma'am, you're up if you're ready. Get close to the microphone and introduce yourself. Go ahead. Thank you.
Thank you. My first name is Mary. My last name is Elizabeth. I have a master's in social work and a background in trauma assessment. The community of Uvalde, Texas was devastated by the shooting at Robb Elementary School on May 24th, 2022, in which 19 children and 3 teachers were killed. The level of trauma that all of the families with kids at Robb Elementary that they experienced was extreme, and the effects will last for years, even decades. The community has been provided numerous resources to begin the process of healing, but their recovery will be limited without their understanding the actions taken by law enforcement on that day. Unresolved trauma has deep and long-lasting effects. It disrupts lives and shatters families. Uvalde strong, yes, but the living trauma continues every day. It is vital that the parents have access to all the law enforcement records from that day. Without this information, there's a significant gap in their understanding of what happened, and that will impair their ability to come to terms with it. For the families and the community as a whole, this blank page in their story only aggravates their grief. For their children to heal, the parents must heal. The children who attended Robb Elementary at that time are growing up now. They face normal developmental challenges as they enter adolescence and adulthood, but these will all be significantly complicated by this traumatic experience. An entire generation of children has been affected, and it is likely that their trauma will affect their own children and their parenting of those children. Families can move toward recovery if they have all of the information they need about this incident. The community needs law enforcement to be accountable and transparent to restore Uvalde's trust in these officers and agencies. Thank you.
And thank you for your testimony. Thank you for being here. Welcome. Introduce yourself and go ahead.
Hi. If you want any more information about trauma, I could provide that later.
Anything you have that's relevant, please share it with us. You can email it to us or give us a hard copy. We value whatever you have for us. Thank you. Go ahead, please.
Okay. Good morning, members of the committee. Thank you for your service and for your time. SB 14 will require all agencies, even though...
Introduce yourself before you get started. Give us your name.
Did I not tell you my name? Okay.
I
My name is
interrupted
Lakshmi Fox.
Lakshmi Fox. Go ahead. Thank you.
Take 2. Thank you for your service and your time. SB 14 would require all agencies, even those with only 1 employee, to maintain a confidential department file that includes a potentially enormous array of documents relating to police and jailers, but certainly including complaints or misconduct allegations. What the Texas Commission on Law Enforcement, TCOL, what their data shows is that 1,227 agencies, that's 44.4%, have 5 or fewer officers. Of those, 542 have only 1 officer, and 331 of them are elected constables. These elected officials would be required to create a department file including all documents related to themselves and allegations that no one will ever see. This bill doesn't fit small agencies. It creates a problem of self-surveillance. If an agency only has 1 employee, they would be required to document, file, and seal misconduct allegations against themselves. It provides the shielding of elected officials. Elected officials like constables and sheriffs could shield their own misconduct record under the guise of confidentiality. If someone files a complaint, it may be quietly buried in a file that's inaccessible to the public or even other agencies. For example, it would require an amendment to make sure that the Texas Rangers Public Integrity Unit could review these documents in a public integrity investigation. Another amendment to authorize access for the Commission on Jail Standards would be needed. This also undermines transparency. Instead of improving accountability, this creates a system of record keeping that reduces public and interagency visibility and will make sure that no agency can be overseen by a local civilian oversight board, unless that is also clarified by an amendment.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Thank you, Mr. Chairman. My name is Luis Sobran with Texas 2036, here against the bill unless 4 words are added, unless required by law, in which case we would be neutral. And we've prepared a handout to help explain why. Under current law, thanks to the near unanimous T-Cole sunset bill that was passed last session, thanks to Senator Paxton, every agency must maintain a personnel file. And the law says that it can't be released to any agency or person unless required by law. Simply put, that means that if someone has the legal right to the information, like a judge, this committee, an executive branch official, or a local oversight body, the agency must release it. SB 14 creates a new department file with similar rules, but it leaves out those 4 words. So when any agency or person would otherwise be allowed to view department file information, the statute would say, unless there is an explicit exception, don't release it. And that's a problem. We have 40 years of Texas case law on statutory construction that warns us about this kind of negative implication. Without those 4 words, it is implied that department file information can't be released even when the law says that it otherwise should be. So they say no one hates a bad cop more than a good cop, and it's because good cops know how quickly trust is lost. And one way that happens is when so-called wandering officers move from agency to agency, evading accountability and then continuing to engage in misconduct. And Texas 2036 reported on this issue back in 2022, and we were very supportive of the T-Cole sunset bill that passed that following session, and it makes significant progress on tackling the wandering officer problem. SB 14, as written unintentionally, makes it harder to keep eyes on that wandering officer problem, but we think that 4 words would help fix it. So thank you, and happy to answer questions if you have them.
And thank you for your testimony. Ms. Bullock, I shouldn't have asked you if you weren't here, but I couldn't see you. I know you've been around a while. Welcome back to the Capitol in this role, and introduce yourself. Go ahead.
Yes, sir. Appreciate it, Mr. Chairman. Committee members, I'm Michael Bullock. I'm the president for the Austin Police Association, representing 1,400 officers of the Austin Police Department, over 1,400 officers. Austin is a 143 city. But some of the things that are important to note is that in 2023, a ordinance was passed that stripped some of those 143 protections away from our department. And subsequently, it was challenged in a court, and then the court upheld that through ordinance, that G file, which you commonly hear it referred to as, can be taken away. So now Austin was put in a position where we did not have a G file. Everything was made public. And much to your point, Senator Perry, is about officers being tried in a court of public opinion before they ever have a chance to get a fair trial. And that is something that we have seen in criminal cases and in some cases administrative ones. So it's a very real problem that we do deal with. And we do have a contract. We have a meet and confer. We're one of the meet and confer cities here in Austin, but we still have struggles. We've filed 3 grievances and 1 lawsuit against the department, against the city, for violating the contract and not abiding by it. So the ironic part in all of this is that Austin is the only city that this bill would not apply to. We're the only city that would still be required to publicly disclose these. Our contract can only supersede Chapter 143 of the Local Government Code. We can't supersede the Occupations Code because that's where our licensure requirements are held, training requirements, and other things. So Austin is a city that has dealt with a lot of public safety challenges, as many of y'all are aware. Your constituents come here. This is the hub for legislative activity, and we have a lot of visitors. Hundreds of thousands of Texans come here every year. So what happens here does affect the entire state. But I find it very ironic we're the only ones that would be excluded from this bill. So our one ask, aside from supporting what Robin brought up earlier, is that Austin not be carved out of this bill.
Thanks for your testimony. And before you testify, we're going to get the next witnesses ready, but go ahead and tell me your name. Make sure we have it right.
Ananda Thomas.
All right, hold on just a moment. Thank you. And so we're going to hear from Ms. Thomas in just a moment. I'm going to ask for the next panel to be coming down to the Senate floor. If you're not here already, we'll be looking for Kirsten Budwine, Nikki Llewellyn, Alicia Castillo, Daniel Illescas, Sarah Beck. Again, we're looking on the next panel for Kirsten Budwine, Nikki Llewellyn, Alicia Castillo, Daniel Illescas, Sarah Beck, and Bill King. Thomas, thank you. Welcome. Get close to that microphone, introduce yourself, and go ahead.
Thank you. My name is Ananda Thomas. I serve as the Executive Director of Act for SA Action Fund from San Antonio. I'm here today to oppose SB 14, which undermines transparency and accountability in law enforcement, core values that build trust and safety across Texas. SB 14 would create a confidential department file for every licensed officer or jailer with any document related to the officer or jailer, including records of complaints, investigations, and misconduct if the officer wasn't disciplined. I want to be very clear here, when we are talking about misconduct, it is not just excessive force. It is things like officers being drunk on the job. It is things like an officer who has detained somebody in their vehicle, stopping by their house, a male officer with the woman in the back, which has happened to my sister, right? We are talking about misconduct that is more than just excessive force, but everyday on-the-job things that happen. And we need to remember that because we need to hold our officers to a better standard, and the public deserves to know that. These records would be kept hidden from the public, from grieving families, from many oversight bodies. Only TCOL hiring agencies, and thanks to the Senate amendments, the Sandra Bland Act, investigators and DAs would have access. But let's be clear, the Sandra Bland Act only covers deaths in custody. It does not cover injuries. If somebody is injured in custody but survives, they may never have the ability to learn if this officer has a documented history of complaints that have gone under-investigated or unsubstantiated, revealing a troubling pattern. When complaints are repeatedly dismissed or buried, it often reflects flaws in the investigative process, not the credibility of the complainant. These red flags would stay hidden under SB 14. Further, an unsustained complaint is not the same as a false one. We must remember this. I know from working with over 14 families that have lost loved ones to police violence how untransparent this process is, how they would like to have more answers, how they feel like they never get them. Please oppose SB 14.
And thank you for your testimony. Senators, is there any questions for any of our witnesses on this panel? We thank each of you for being here. Thanks for your testimony. Call Kirsten Budwine, Nikki Llewellyn, Alicia Castillo, Daniel Illescas, Sarah Beck, Bill King, Lauren Pena, Ruth Moonsingy, all right, welcome to each of you. We'll give you a minute to get situated there. And go ahead, have a seat. Have a seat. You're welcome right there. All right, if you're ready, we'll start over here. Make sure you're close enough to the microphone and welcome. Give us your testimony.
My name is Ruth Munasinghe, and I'm against SB 14. Senator King is a reasonable member with a law enforcement background. However, on this matter, we see things from a different lens. I'm viewing this issue from the eyes of a mother. The police force is an agency, like the legislature, meant to serve the general public. And yet, in response to public wishing to have reasonable insight into the performance of its police officers, SB 14 draws a curtain around G-files. The police uniquely hold our safety, our very lives in their hands. I've heard arguments that G-files are records that explicitly do not merit formal discipline, subsequently not warranting public disclosure. However, in this job, where every day results in deaths of police officers and the general public alike, the expectation of accountability should be elevated. Officers are special members of our community, tasked with protecting and serving. Thus, we should understand that a veil is not a tool they should have in their arsenal. As a mother, I have seen firsthand what can happen when we don't have transparency. My son was taken from me by an APD officer, but instead of transparency and accountability, I stand here almost 3 years later with many more questions than answered. I am left not just grieving the loss of my youngest child, but without faith in a system I once profoundly believed in. I think Senator King, may I finish?
Yes, ma'am. Go ahead and
I
finish that
thank
thought.
Senator King for the amendments proposed to create limited, and I underline limited, access to these important records. I will never agree with the underlying principle that those charged with our safety, entrusted with firearms, should be immune from public scrutiny. Thank you.
And thank you for being here. Thank you for your testimony. Welcome. Introduce yourself and go ahead. Yes, sir, you're up.
Good morning, actually, good afternoon now. My name is Bill King. I'm a retired judge. Since retirement, I've spent time advocating for good governance. Senate Bill 14 is a good bill insofar as it provides for a more uniform procedure from compiling and maintaining records. The problem is, and my concern is, that access to that information appears to be limited to law enforcement agencies. Some cities have city review commissions for complaints against police. Will these commissions still have access to files? Individuals can bring civil lawsuits against police officers. Will they have access to these files? The basic problem is that only letting some police monitor the conduct or alleged misconduct of other police has never been that effective. I lost count of the number of times law enforcement officers were, let me just say, less than truthful on the witness stand in my court. I never got any feedback about whether there was any accountability for that misbehavior. Imagine how much more difficult it is in a street situation. Having effective accountability measures is critical for police agencies. The public needs to trust them. Law enforcement officers hold tremendous power, and the public deserves to know that police mistakes are dealt with properly. The public must be able to trust that their police public servants are acting properly. And hearing everything today, the back and forth from all these different experts and people, it seems like the thing to do is just to pull SB 14. It's unclear what it says, apparently, to almost everyone who's testifying, and the committee for that matter. And I would suggest that you pull it until there are clear safeguards that are added to it that enhance police accountability instead of potentially hiding it. Thank you.
And thank you, Your Honor. Welcome back. Introduce yourself and give us your testimony.
Hi, my name is Sarah Beck, and I'm a born and raised Texan. I'm here to ask you to oppose SB 14. This bill at minimum will severely limit, and at worst, completely prevent people, including citizens, reporters, and lawyers, from accessing police misconduct files. As citizens, our government and police are meant to protect and serve the people. Transparency is essential. This proposal of police completing their own internal investigations without witness is absurd. We already have issues with police getting paid leave and then only getting a stern talking to after unjustly harming citizens. In the city of Austin, we have an Office of Police Oversight, but they can't even discipline police. It is still left to the police to discipline themselves. I'm concerned how much less effective this oversight will be, or if it will be dissolved. I'm even more concerned for cities that don't have any oversight offices or checks in place. This attempt to blindfold the public from seeing the misconduct is extremely worrisome and problematic. This bill would prevent any opportunity for public trust. I urge you to oppose this bill. Thank you.
And thank you for your testimony. And welcome. Introduce yourself and go ahead.
Thank you. Good afternoon, committee. I am Nikki Llewellyn with the ACLU of Texas. Thank you for allowing me the opportunity to testify against SB 14. Senate Bill 14 represents a direct threat to safety and justice and establishes a system where police agencies can bury and withhold virtually all allegations of misconduct at the agency's discretion. Those records would be out of reach to the public, reporters, lawmakers, civilian oversight bodies, and even the governor and lieutenant governor. The tragic events at Uvalde illustrated the deadly consequences of inadequate police accountability when 19 students and 2 teachers lost their lives. The struggle to access investigative records to evaluate law enforcement failures during the shooting revealed glaring gaps in oversight. An investigator's conclusion of no wrongdoing only deepened the mistrust about independence of such reviews. SB 14 would amplify these problems by making it even more difficult to identify troubling patterns of misconduct. The bill's restriction on access to critical records compromise public safety and further erodes police and community relations. This is evident in cases like Derek Chauvin, whose documented history of excessive force complaints went largely unaddressed before his murder of George Floyd in Minneapolis. When police departments have sole discretion over what misconduct remains visible, we risk repeating the same catastrophic failures. Transparency and accountability are the cornerstones of justice. When law enforcement operates openly and officers are held responsible for misconduct, it makes all of us safer. Texans deserve better. We need greater transparency, not less. So for these reasons, I urge you to please vote no on SB 14. Thank you.
And thank you for your testimony. And welcome. There you go. Get close to the microphone. Introduce yourself and go ahead.
Yes, my name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project here in opposition to SB 14. So according to the bill analysis, this bill is meant to address concerns about the release of sensitive information related to licensed law enforcement officials. We have not heard any examples where sensitive information was legally released to the detriment of an officer's safety or well-being. But even assuming that has been an issue, the bill's provisions seal far more information in a way that weakens transparency and threatens to undermine accountability. There has been a lot of discussion about unsubstantiated misconduct claims, but subsection C of this bill requires that the confidential department file include much more, including all documents related to a license holder that is not in their personnel file. This will effectively make secret a significantly broader range of documents than the bill author intends, including records unrelated to misconduct that do not contain sensitive or personally identifiable information about the license holder. If the goal is to prevent officers from harm due to the release of records about them, at a minimum, the bill should be amended so that the contents of the new confidential department file include only those documents that have personally identifiable information about the license holder. In addition, the same subsection requires the concealing of documents related to alleged misconduct that is deemed unsubstantiated. It's important to note that the bill does not require an agency to conduct an investigation before making that determination. Therefore, this bill should be amended to ensure that an investigation is conducted before claims of misconduct are deemed unsubstantiated. It should also clarify that documents related to such claims are not required to go into the confidential department file if personally identifiable information is redacted. Preserving public access to records regarding taxpayer-funded public services is essential for transparency and community trust in law enforcement. Thank you.
And thank you for your testimony. Senators, any questions for any of our witnesses on this panel? Very good. We thank each of you for being here. Thanks for your testimony. You're excused. There are some names that we have previously called, some we may have missed, so I'm about to call the names of the remaining witnesses we have registered to testify. And so I call Alicia Castillo. All right, welcome back. Daniel Illescas, Lauren Pena, Julian Reyes, Brianna Arredondo. And again, I think I'm calling Julian Reyes and Brianna Arredondo for the first time. So again, we're looking for Alicia Castillo, Daniel Illescas, Lauren Pena, Julian Reyes, Brianna Arredondo. Now those are, I've called every name that we have registered to testify that has not yet testified. If there's anyone present wishing to testify on, for, or against Senate Bill 14, please make your way to the Senate chamber and make yourself known to us so that we can hear from you. And so with that, we will get started on this panel. Welcome to each of you. We're glad you're here. And if you're ready, introduce yourself. I know you want to get that right. Make sure you're close enough to the microphone. We can hear you. And go ahead.
I'm Julian Reyes, and I'm against SB 14. Can you hear me okay?
Yes, sir. Go ahead. We got you. Thanks.
I'm a member of the press, local 501c3 nonprofit called the Challenger Street Newspaper. We're international. We're involved in international trade. I've just won a federal case against APD in the city for violating press rights. I've filed over 100 police complaints against APD. They keep them secret. Under their meet and confer, even my own complaint information is secret. I've heard a lot of lies from witnesses that have come before you guys. I've heard a lot of ways of renaming obfuscation of evidence in both civil and criminal cases. I've been a victim, myself and Brianna here, have both been a victim of police retaliation for filming the police when they're involved in citizen arrests and citizen interactions for pedestrian Class C misdemeanors, things like that. They'll retaliate for anything. And so I filed 100 police complaints, and almost all of them, they cleared themselves. So I don't know what you guys know about Austin Police Department, but they have faced corruption in the media and in the courts. The lawyers say that there's the Brady list, there's a G file, there's a bunch of crooked police officers that can't testify against you on the Brady list because they're felons, or they've already perjured themselves on other cases, or they've been involved in felonious activities, including assaults, sexual assaults, and things like that. That's a big thing at APD. That's what people like Michael Bullock like y'all not to know, is that we have a very ingrained, corrupt, protectionist organization in the Austin Police Department, and they're already involved in obfuscating evidence under Michael Morton Act for pro se litigants, which I didn't hear anybody talk about. I hear people talking about, like, if you have a criminal case and your attorney gets information and the judge can parse it in certain cases and there's a meet and confers and stuff. But if you're pro se, they obfuscate everything. They refuse to give you any evidence. I have lots of evidence for this. If you guys would like to talk to me, I can send you emails. I got a lot of background on this stuff. But basically, people like me don't come forward and risk our lives to put a bad cop on report fictitiously. The cops are clearing themselves. That's why these cases are unsubstantiated. And it's the
Thank you for your testimony. Anything you have for us, please submit it to us, and it'll be in the record, and we'll take a look at it.
You guys, like, is there someone I email?
Email's the best way. Yes, sir. Mine is brian.hughes@senate.texas.gov, and that's the formula for each one of us. Go to the Senate website. There's a portal, however you want to do it, or bring it by the office. But again, whatever you have, we want to put it in the record and make sure everybody sees it. Thank you for your testimony. Welcome back, both of you. Introduce yourself again and give us your testimony.
Hi, my name is Alicia Castillo. I'm representing the Texas Civil Rights Project, and I don't want to belabor any of the points that have been made here today, because there certainly have been a lot of points, a lot of good suggestions for ways to improve this legislation. Texas Civil Rights Project is opposed to the legislation, but at a bare minimum, I think after listening to all the conversation today, after many of you have been looking at these pieces of code for much longer, but I've spent about 4 years really studying these parts of the code most recently. And I think it warrants a longer discussion and perhaps even an interim study. I mean, a special session feels a little bit rushed to push this through when so many questions have come up. And so with that, would love to speak with any of your offices and hope that we can put a pause on this legislation for today. Thank you so much.
And thanks for your testimony. Welcome, introduce yourself, welcome back. Go ahead.
Hi, my name is Lauren Pena. I'm currently running for United States Congress here in Travis County. It'll be the new District 37. For those of you who don't know, I am a survivor of human trafficking in this district for 10 years. I come with an abundance of information, and I fully agree with a lot of the things that this man said over here. And I am testifying neutral to this bill because I just want to raise awareness, give my perspective. I want to ensure that when I get to Congress, I am able to expose these things because everybody is so mad about Jeffrey Epstein. There are many Jeffrey Epsteins in the very city you're sitting in right now, and I am willing to bet anything on it. It's like that in every capital city, but the cities in general. And so I just want to ensure whenever we create this legislation that that's not going to prevent me from exposing the truth on how these things are really all tied in together, because it's time that we do get the accurate transparency that we deserve in Texas and in America. So I'm more than happy to answer any questions, and I mean that broadly. So feel free to ask me. Thank you.
And thank you for your testimony. Welcome, introduce yourself and go ahead.
Hi, my name is Brianna Arredondo, and I know that the previous SB 7 was already closed, but I oppose on SB 7 and I oppose SB 14. How are I keep hearing about unsubstantiated claims. How are they unsubstantiated when people are actually making a report, a real report? Like they're saying, you know, the police officer is doing excessive force, and not only that, but they also rape women, you know, and it's being secret. Like, how are you going to have public trust when you're keeping public records that the public demands to be public and transparent? How are the police officers, they're always talking about, we're all about accountability, we're all about transparency. It's a lie. They're lying to you. And it's all corruption. It's all corrupt. They're corrupt, the government's corrupt. You know, it's being pushed by the police unions, the APA, the TCO. They're pushing this. They're trying to push this legislation to make it harder for the public to have access to the accountability, police accountability. And there's a lot of police violence going on. How is the public going to trust the law enforcement? You know, and I mean. There's not going to be no public trust at all with the law enforcement ever, because there's no transparency. There's none. There's no accountability. It's all corrupt. That's all it is. And please oppose this. Do not vote for, please vote no for SB 14. And I oppose SB 7 too.
Okay.
Thank you.
And thank you for your testimony. Senators, any questions for any of our witnesses on this panel? Very well, thank you each for being here. You're excused. Thank you. Now, those are all the witnesses that we have registered, expressed a desire to testify on, for, or against Senate Bill 14. Is there anyone else present wishing to testify on, for, or against Senate Bill 14? So come on down to the table. Let us hear from you. Hearing and seeing none, public testimony is closed. And Senate Bill 14 will be left pending at this time. Members, any other business come before the committee at this time? Very well, we thank each witness, regardless of your position on the bills. Thanks for staying with us. Thank you for our excellent Senate team that keeps things going and operating smoothly, keeping everyone safe. I thank the members and their staffs, our excellent committee staff. And with that, the Committee on State Affairs stands in recess up to the call of the chair. Good evening.